So examiners is the short answer. So if you file a patent, your application will be assigned to a U.S. patent examiner. And the U.S. patent examiner is the individual who ultimately decides whether or not your invention is patentable. Now, when your application is assigned to an examiner, he or she has a docket. So they have several patent cases that they're responsible for. So they don't get the notification and right away turn to it, right? But when they do eventually get to your application, what they're going to do is they're going to review the claims in your patent application. They're going to try to read the specification and review the drawings and try to understand the claims. And then they're going to do a patent search. So they're going to search through the Patent Office database for both patents and published patent applications. And they probably will also might use other databases such as Google or any other search mechanisms that they have at their fingertips to try to identify prior art. Now, prior art lives in a lot of places. You can usually find a lot of prior art on Google. And what they usually do, what we typically find is that they usually cite prior art in one of two places. So one is from the registry of issued U.S. patents, and another source is published patent applications, published U.S. patent applications. Those tend to be the two types of prior art that are cited by an examiner. Now, that's not necessarily limited to just that. Sometimes, I mean, I have seen examiners cite Amazon listings, product sales pages. There's all kinds of prior art out there that exists. And so, but it's ultimately the examiner that's going to make that determination. And where that determination is made is in an office action. So they will issue what's called an office action after they have had an opportunity to examine your patent application. And what's an office action? So an office action, we call it an office action on the merits. An office action on the merits is that decision, that determination of patentability. And typically what we find is that in the first office action, depending on how broad your claims are, the patent office examiner is typically going to issue a rejection. And that rejection is going to be typically one of two types. So one is a rejection based solely on one piece of prior art, sometimes also referred to as a Section 102 rejection or an anticipation rejection, or it's rejected over a combination of two or more references that are combined. Those types of rejections are called Section 103 rejections or obviousness rejections. Now, these determinations of patentability can be rebutted. So you can argue either that they say the examiner has mischaracterized what exists in the prior art. So they have identified some element in the prior art that doesn't actually exist, or the reference doesn't actually say that it's there. Or you can amend your claims to get around the prior art identified by the examiner. So those are two mechanisms, two strategies, two general high-level strategies for responding to these rejections on patentability. Who decides if my invention is patentable? That's a U.S. patent examiner. Who decides if my trademark is possible to be registered in the principal register? Well, it should be no surprise, it's a U.S. trademark examiner who's going to make that determination. Similarly, to patents, your trademark application will be assigned to a U.S. trademark examiner. And the trademark examiner is going to also do a similar type of search, but they're not looking for prior art. They're looking for what are called confusingly similar marks. So they're going to search the trademark database and try to identify other marks registered before yours that might confuse a consumer. So a U.S. trademark examiner is going to perform an analogous function, but for your trademark application. Now, the one big thing, and depending on whether or not you're pursuing a patent or a trademark, this might actually really matter to you. The determination for trademarks tends to occur much, much more quickly. A U.S. trademark examiner is typically assigned within 3 to 8 months. We've been seeing it closer to 3 months, and they'll make a determination within that time period, within 3 to 8 months typically. And so basically, I'm just saying that trademarks are much more quicker in terms of determining whether or not it's possible to register a trademark. Patent, on the other hand, it usually takes 2 to 3 years to be assigned to an examiner. There's always exceptions, right? Sometimes patents are assigned much more quickly. Other times it takes much longer.